the other point to bear in mind, I think, with the buying and selling transaction is that from the outset, you get an idea of who you're dealing with. If you don't trust that person from the start and they've not been entirely honest with you, you might want to question whether they could be one of these people that leads you up to exchange or completion and then fails to complete. So I think there does have to be some element of evaluation of who you're dealing with and trust between the buyer and seller as much as that is possible in this type of transaction.
Welcome to Listen Without Prejudice, your exclusive gateway to one of London's leading law firms. In each episode, we dive deep into the stories, insights, and expertise that make Bishop Sewell a trusted name in the legal community. Join us as we explore everything from the latest legal trends and case studies to practical advice on residential and commercial property, corporate and commercial law, employment, family and divorce matters, private clients, and dispute resolution. Whether you're a legal professional, a client, or simply curious about the law, Listen Without Prejudice is here to inform, inspire, and engage. Now, without further ado, let's get the conversation started.
Hello and welcome. I am Thom Wilkinson, the head of property at Bishop Sewell, and today I am discussing potential pitfalls of property purchases with one of my colleagues. I'll leave you to introduce yourself, Karen.
Yes, Karen Bright at Bishop Sewell, head of litigation and insolvency.
Many thanks. So I wanted to start really with the beginning of a transaction, and hopefully things won't ever go wrong, but if they do, what are the warning signs? Or what are the complications with matters as well? So the first question I wanted to put to you was one that a lot of buyers will have for property, which is, should I pay a holding deposit to reserve a property, and what are the risks if I do?
Okay, it's an interesting question. We often get people calling us when things go wrong on this. Most important point to bear in mind is that if you're going to enter into any agreement, particularly where you're paying money, and it probably will be phrased as non-refundable, is that you get your solicitor to look over the agreement to check what the terms and conditions are so that you know exactly what you're signing up for. One point to bear in mind is that if you're paying the money to take the property off the market and the other party defaults, you would hope that you would get your deposit back, because that's something outside of your own control. So it's most important is to get your solicitor to look over it, to explain the terms and make sure that it's fair. There's no reason why you can't try and change some of the terms and conditions if they are unduly onerous.
I mean, you think of examples of those. I mean, what things that I've sort of worried about when looking at these for clients are time limits or time that they have to exchange within, or even, as you said, the issue if a property has a defect, something needs resolving, which would cause a lender not to want to lend, for example. Are those things that you look at and see regularly in these?
They are. I mean, often it might be, say, a developer who fails to do something. The client has paid the deposit already without taking legal advice, and then they can't get their deposit back. So it's really important that they understand exactly what they're signing up to, and if they can get the deposit back, in what circumstances it is.
The next question I had, sort of moving on through a transaction, is, and this time looking at it from a sort of seller's perspective, if you've had a disagreement with neighbours or something similar, or even issues with the property, and we can think of some wonderful examples of this shortly, but what do you need to disclose to a buyer? I mean, thinking particularly in terms of filling out the information forms at the outset.
So the first thing is for the client to actually understand the question being asked. The requirement is to answer the question, not to provide what you think needs to be said. So if you're being asked, have there been any disputes with neighbours, then you need to answer just that question. And if there has been any, you should disclose it. For instance, there might be questions about, have there been any complaints from your neighbours? And there may be noise, that's a common one, music, loud parties. If you say nothing about it, the transaction completes, the buyers move in, and then they have an issue with the noisy neighbours, and they go around, for instance, and complain, and the neighbour says, I used to have this conversation with your predecessor and you've not disclosed it. It's very clear that there is a potential misrepresentation here about neighbour disputes. So it's really important to be honest, to answer just the question that's being asked. Normally, I think from the transactions that if you got a reply back saying that there was an issue with the noise from the neighbour, you'd probably then ask to have further correspondence or information. Would that be what you'd ask for?
Definitely. And to sort of add in terms of the transaction as well, one of the things that we like when clients give this information up front is A, they are the best person to explain it fully because it's their potential issue. But also B, you can then deal with it promptly as part of a sort of a smooth transaction, rather than have something that someone's not wanted to deal with and has then come up midway through the transaction, which then makes the buyer more wary and normally takes longer to solve at that point. So certainly from a transactional perspective as well, it's really helpful when people volunteer these issues as early as they can.
Yeah, and I have seen it where people haven't disclosed items, and there's been some press coverage recently about the moth infestation in a London property where the courts actually undid the transaction and there were substantial damages paid as a result of that misrepresentation or non-disclosure of the issue. We've also seen it where there has been something wrong with the property, has been a particular question asked and there hasn't been a truthful answer given, and it potentially opens the person who's made the misrepresentation up to a county court or high court claim, depending on how much is at stake here, how valuable the property and the damages are.
No, certainly, and particularly talking about the Moth cases, that's very much in the public eye at the moment. Was that an unusual verdict, particularly bearing in mind it unwound the sale? It's
unusual for a sale to be unwound. Usually you would get damages, compensation for what your losses are. So in some circumstances, if you had a vermin infestation that you could get rid of, it might be the cost of replacing clothes or furniture, carpet, something like that, to put you in the position you would have been had you have known about this issue and been able to deal with it, or similar, something to compensate you for that.
And that was certainly a salutary tale for us all.
I suppose the other point to add to that is that if somebody's thinking about selling their property, and bearing in mind their duty of disclosure when asked questions, is to not start an issue with your neighbour or similar, because you will probably need to disclose it. It's best to perhaps sit tight and not create a problem if it can be avoided.
Fair enough. Very good advice, I think. Moving on through the sort of part of a transaction, another sort of potential problem area is sort of the emotionally fraught period around completion, when people have got movers, they're selling one place, buying another. It's all got to happen seamlessly and smoothly. So can you give us a bit of advice on what happens if completion doesn't take place on time on the completion date? And that's, if possible, looking at it from both the buyer's perspective, if the seller's not ready, or the seller's perspective, if the buyer, or in particular their lender, isn't ready.
So the first thing is, if completion doesn't take place, is you need to speak to your solicitor, obviously. The news has probably come from your solicitor. And if it is the other party that's in default, your solicitor needs to make sure they serve the completion notices, because under the contract, time is not of the essence, as you know, until you serve the notice to complete. However, as a cautionary tale there, you must be ready and able to complete yourself. So it would be foolish to serve that notice to complete if for any reason on your part you are unable to complete that transaction. For instance, say your mortgage funds have not arrived or there is some other hold-up. So assuming that you are ready, willing and able to complete, serve the notices, and then the defaulting party has a period of 10 clear working days in which to complete the transaction. If they don't complete the transaction, there are a number of choices open to that party. If they are the buyer, then they can ask for the return of the deposit. If they are the seller, then they can elect to forfeit the deposit. And also that there can be a claim for damages. So in the event that you've got a long chain of sales and purchases, there's likely to be interest running under those contracts. There might be losses for cancelled removers, maybe overnight accommodation, other things that directly flow from that breach of contract, from that person not completing the transaction when they should. The other point to bear in mind, I think, with the buying and selling transaction is that from the outset, you get an idea of who you're dealing with. If you don't trust that person from the start and they've not been entirely honest with you, you might want to question whether they could be one of these people that leads you up to exchange or completion and then fails to complete. So I think there does have to be some element of evaluation of who you're dealing with and trust between the buyer and seller, as much as that is possible in this type of transaction.
No, I think so, definitely. And one thing I would like to point out is it's a very, very small minority of transactions where it would be an issue that they're unlikely to complete, although it is a possibility. And as you pointed out, usually this can be dealt with within quite a small period of time, and the usual remedy, particularly if it's a buyer that's not ready, would be contractual interest under the contract. So whilst they are all concerns, and it's things to think about in the lead up to exchange, it's a matter of making sure, shortly before exchange, that you're ready with everything you will need for completion.
And it always seems to go wrong on a Friday because most completions are on a Friday.
There is that. If it's going to happen, then yeah, it will probably be a Friday. I'd like to move on now from sort of sale and purchase transaction to look at leaseholds in particular and the element of service charges within them, which I know can be an issue, one you look at when you're purchasing a property, but also on an ongoing basis if you are living in a flat. And I suppose the first bit to ask you would be, are there any limits to the amount a landlord can charge a tenant for service charges? And if so, what are they, please?
Well, it's a very topical point, isn't it, service charges at the minute, with the whole government reform in this area, trying to deal with unruly landlords and tenants being exposed to hefty service charges. So the starting point, as with all leasehold properties, is to understand exactly what is in the lease. If there are repairing obligations that the landlord's required to do and a service charge mechanism for recovering the costs that the landlord spends, then generally speaking, that would be unlimited. So you're open to the landlord spending money without any limits. That said, there are statutory provisions that protect tenants for reasonable charges to go through the leases only. So what that means is that what a landlord does must be in accordance with the lease. So for instance, if you've got a repairing obligation to paint the exterior of the building every 3 years, the landlord is entitled to do it every 3 years to keep that building in the condition it needs to be. But those costs must be reasonable. They cannot be whatever the landlord decides. It needs to be invoices for them. And if there are concerns that these costs are excessive, the tenants may wish to look to get some comparator quotes to see if they could prove that the works could have been done for cheap, for lower cost than what the landlord's charging. There's also another cap, which is called major works cap. So if you are going to carry out works which are going to cost more than £250 per flat in a year, then that requires a statutory consultation. The landlord's duty is only to consult with the leaseholders. So often leaseholders will think that they can stop the works. They can't. They just have the rights to be consulted, to have a list of what those works are, and to nominate contractors. Then the landlord is required to obtain, where it can, at least one quote from one of the tenant's nominated contractors. And then the landlord can pick whichever contractor he wants. If it's not the lowest, he has to give reasons as to why he has picked that contractor. So going back to your question, is there a limit on service charges? Not under the terms of the lease, but statute has imposed some limitations to help leaseholders in this position. And it is open to leaseholders, if they want to challenge those costs within the first tier property tribunal.
I suppose for completeness, I should say that there are lots of other service charges which fall outside the repairing obligations. And see, when you're saying you get the solicitor to look at the lease, we always look at the additional bits. So if they're paying for a gym or a concierge or porter or similar provisions, those will be within the service charge as well. So there's no such thing as a free lunch, unfortunately.
Absolutely not. And one that we always seem to hear about are the leaseholders who live on the ground floor. that don't use the lift but are required to contribute to the lift. Unfortunately, if it's in the lease, they have to pay for it, obviously subject to the reasonableness, but the lease is a contract and therefore they're bound by its terms.
Absolutely, and I've seen similar ones, even with clients looking to argue that on the ground floor they shouldn't be paying for the roof replacement works, but I'm afraid it doesn't quite work like that. Absolutely. I suppose one thing that does come out of this a bit further, though, is what is a sort of tenant's or flat owner's remedy if they're paying the landlord for services but those are not being provided?
Okay, there are a couple of options there. It's always worthwhile in this situation consulting with a lawyer or solicitor before jumping into any course of action. So under the terms of the lease, which is a contract, you've got the possibility of applying to the court to compel somebody to comply with their obligations under the lease. You potentially also have a claim for damages if, for instance, the lack of repair, say to a roof, causes water ingress and you suffer as a result of that. You can claim your losses there. The other option is if you've got a problem with your landlord not complying with its repairing obligations and perhaps making it difficult when you come to sell the property by not giving you the required landlord forms. The other option is to apply to the tribunal to appoint a manager to manage the property. But it's quite a complex and in-depth process and there are some hurdles to jump through. So it's probably a conversation for another time on this topic. But those are the main options: county court claim or to apply to the tribunal. I suppose that the first step should be to actually write to the landlord, send them correspondence, notices of the issues, and give them a chance to respond.
Absolutely. I think that's very salient advice. Obviously, within this topic of service charges, we could also touch on cladding and the various issues around that and how that affects service charges. But I think that's probably a discussion for another day. So I'd just like to say thank you very much for your very helpful advice, Karen, and look forward to picking up on these subjects again soon.
Thank you very much.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial, or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and challenges across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.